Hey everyone, I'm Kristen McIntosh, the Happy Lawyer here at Schweitzer and Associates. Welcome to our monthly webinar series. Today we are going to be taking on the topic of tales from the crypt and how to avoid estate planning nightmares. Today, just for you, I'm going to open up the Schweitzer and Associates vault of bad estate planning stories. After reading these stories to you, I'm going to point out some ways that you can avoid the estate planning mistakes made in these stories. That way, your estate plan will not be a horror show. After all, scary horror shows are for Halloween, not for estate planning. So sit back, relax, listen, and learn. If you have any questions, type them in the comments below. Ready to embark on our adventure? Before we begin, I want to tell you just a little bit about myself. Again, as I mentioned, I'm Kristen McIntosh, the Happy Lawyer at Schweitzer and Associates. Now, many people worry that their loved ones will be left with a mess when they die, and that's where I come in to help them. I listen to my clients' unique needs. I then offer them strategies for dealing with those needs, and then I create a personalized estate plan just for them. I believe that no two clients are alike, so why should their estate plan be the same? Here at Schweitzer and Associates, you will not be getting any cookie cutter estate plans from us. That's because I save my cookie cutters for baking lovely homemade goods for our clients. Now, today's agenda, we're going to cover 5 nightmares. The first nightmare is not having a will. Nightmare number 2 is going to be failing to complete your estate plan. Nightmare number 3 is the do-it-yourselfer. Nightmare number 4 is going to be covering family disputes. And nightmare number 5 will be failure to change your estate plan. Okay, so we're ready? I'm going to open up the vault now. First, nightmare number 1, you should have left. A tale of the man with no will. Once there was a man who was not very wealthy, so he decided he did not need a will. One dark and stormy night, the man passed away suddenly. His wife called his parents, who were still alive, to tell him of the terrible news. When the parents arrived, they looked all over the place, but no will could be found. A bitter battle ensued between the parents and the wife over who would administer his estate. A lengthy and expensive legal battle ensued, and at the end of the day, not only did the wife and her in-laws have to pay out a lot of money to the lawyers, the wife had to split her husband's property with her in-laws, including the house she lived in during her marriage. The wife had thought her nightmare was losing her husband, and now she realized her nightmare was just beginning. So this kind of shows you what can happen if you do not have a will. If you don't leave a will stating your wishes and desires, North Carolina already has an estate plan ready for you, so don't worry. It's called the intestacy statute. However, I need to caution you, you may not like the North Carolina's estate plan. So let's visit that based on your life changes. First of all, we're going to cover what happens when you're single when you die and you don't leave a will. Well, let's assume that first, you don't have any children, but your parents are still living. In that case, all of your property is going to go to your parents. If both of your parents are deceased, then all of your property is going to go to your brothers and sisters. Now, North Carolina doesn't care if you like your parents. They don't care if you like your siblings, if you haven't talked to them in 20 years. The fact of the matter is, if you don't leave a will, that's who's going to inherit your property. Now, let's say you're married. You don't have any children, but your parents are still living. What happens then? Well, shockingly, your spouse will get half of your estate, and then the other half will be split between your in-laws. That's right, your husband's or spouse's parents are going to be sharing everything with you if your spouse did not leave a will. Hope you like your in-laws. Now, what happens when you're married, spouse dies but didn't leave a will? This time you have children. Well, now your in-laws aren't going to inherit everything, but now you're going to have to share your husband's property with your children, which may be good, but it may be bad. Let's say, for instance, you have a 16-year-old and the two of you have been battling constantly and not getting along. Well, now not only do you have the parent-child dispute between you that we all go through as parents, you're now going to have to deal with that child anytime you want to sell any of the property that your husband left. So not an ideal situation at all. So the moral of this story is get a will done. Okay, we're going to go back into the vault for nightmare number 2. Nightmare number 2 is the monster house, a tale of the unfinished estate plan. Now this time we have somebody who started a will. In fact, his name was Stan, and Stan was a man with a plan. However, Stan was also a major procrastinator. You see, Stan was very wealthy and he knew he needed a will. So he made an appointment with his estate planning attorney who began drafting Stan's will. However, Stan, like all of us, became very busy. His attorney would call and call and call, and Stan would always make an excuse as to why this was not a good time to come in to review the drafts and to sign his estate plan. Stan began to feel overwhelmed with the choices he had to make to complete his estate plan, so he was also fearful about completing that estate plan. He also became anxious as his unsigned estate plan was a reminder of the fact that he was not immortal. Besides, he was young. What was the hurry? Well, one night, Stan left work and splat, he was run over and killed by a drunk driver. His family was very upset, but they knew that Stan was responsible and had met with his estate planning attorney. After all, Stan was a man with a plan. So a phone call was made to that attorney asking about the will. The phone line was silent for a moment, and then the attorney spoke. There is no estate plan. You see, Stan never signed his will. Stan's wife passed out immediately, and the phone line went dead. Don't let this happen to you. Because an unfinished will is the same as not having a will. You know, many people procrastinate about completing their estate plan. In fact, some people even procrastinate about going to an attorney. But no matter what your reasons are for procrastinating, the results are the same. Your unfinished will or trust is unenforceable, and the law will treat it the same as you having died without having a will. Can we say hello, North Carolina intestacy statute? So let's go back into the vault for nightmare number 3. Nightmare number 3, the Labyrinth, a cautionary tale of the do-it-yourselfer. Now see, there was a smart but thrifty man who knew that he needed a will. However, being thrifty, he did not want to pay a lawyer to prepare his estate plan. He thought, why should I spend money on a lawyer when I can do it myself? There are plenty of online will kits that I can use. How hard can it be? So he drafted a will online, leaving everything to his daughter with the expectation that she would do the right thing and split her inheritance with her brother. You see, the brother was kind of down on his luck. He was going through a bad divorce and thinking about filing for bankruptcy, so he wanted to protect his assets and not inherit outright from the will, which is a public document. So before he died, the father spoke with his daughter and told him about his intentions and expressed his wishes that he wanted her to share The inheritance he was leaving solely to her in his will with her brother when he died. Well, the daughter, being the good, dutiful daughter that she was, she smiled and said, "Why, yes, Daddy, I'll make sure to do that." Well, Dad dies the next day. Daughter then probates the will, and she keeps all the money for herself, cackling all the way. Some say you can still hear her laughing late at night along with her poor brother's agonizing wails of sorrow. You see, when you make a do-it-yourself will, you can make mistakes. For instance, let's take the case of somebody who once left somebody $200 instead of $200,000 because he inserted a decimal point instead of a comma. Yep, that actually happened. Imagine that person, his heirs surprised when she thought she was inheriting $200,000 and found out she actually was only inheriting $200 due to a typo. And once there was the time somebody left the words fill in the blank here, forms have that, and you're supposed to actually, write a name. Well, they forgot to do that. So that person's spouse, who was supposed to be the person inserted in the fill in the blank here line, ended up not receiving anything under the will. They had to go through the intestacy statute. I don't think that wife was very happy. Also, a good estate planning attorney can help you with tax saving solutions for your heirs, such as, did you know that you can pass on your unused estate tax exclusion to your spouse after you die? Yeah, you can. Sorry, single people. You don't have that advantage. But for you married people, you do. The current exemption right now is $22.36 million for a married couple. That means if your spouse dies and only used $1 million of that exemption during his lifetime, he can pass on his unused $10.18 million exemption to his wife through his will for when she dies. But this exemption, again, is not automatic. It has to be stated in the will in the correct way. Now, as a non-lawyer, you may not know of all the provisions that you need for your current life situation. Imagine the parents who died in a tragic accident but forgot to name guardians over their children. After they died, a huge custody fight over the guardianship of their children ensued, and the poor children were shuttled back and forth while the relatives spent lots of money and were very angry with one another until a court decided who should have custody of the children, which may or not have been the person the parents would have wanted to take care of their children. And then I once had a client who brought in a do-it-yourself will. Now, he had done it online, luckily had not signed it, but when I was looking at it, he had taken some estate provisions, then he had taken some trust provisions and combined them into this document that was all a jumble of legal provisions that made no sense whatsoever. And I asked him, I'm like, did you want to have a trust, or were you just wanting to have a will? And he's like, oh, I just want a will. And I'm like, okay, then we need to sit down and totally redo this. Good thing he came to me, because had he actually signed that document and died, nobody would have, it would have taken a court and the heirs a long time to figure out exactly what his intentions were. And we don't want our relatives to be stressed out on here. All right, going back into the vault, folks. Nightmare number 4, and then there were none. You see, one dark, rainy morning, Thrifty Tom gathered with his sister Spendthrift Sue and his brother Down on His Luck Doug in a lawyer's office. You see, earlier in the week, their mom had died, but had left paperwork saying that her lawyer had her will and to call him to get the will. So they did, after a reasonable amount of time for mourning had passed. And now they're all three sitting in the lawyer's office, who began passing out copies of the will to all of them. All of a sudden, Thrifty Tom sat up in his chair and screamed, "This isn't fair! Why is Down on His Luck Doug getting all of more than I am?" Spendthrift Sue stood up, knocking over a chair, exclaiming, "Why is my inheritance in a trust, but the two of you are getting your inheritance outright?" Their voices got louder and louder. Furniture was knocked over. A glass was thrown. Shouts of "Mommy loved you better," and "You always got more than I did while we were growing up," rang out throughout the lawyer's office. Soon, a brawl ensued, and the security had to be called. As the children were being dragged out of the office, pulling hair and ripping clothes off of each other, the lawyer just sat there shaking his head. He realized that despite his advice, his client had obviously not talked to her children about her intentions and why she decided to do what she did. "Why do my clients always think that their children know how they want their estate divided?" he muttered as he sat all alone in his dark office. "When will my clients believe me when I tell them, 'Trust me, your children will not understand why you are treating each of them differently'?" That's why I always advise my clients that when it comes to family, you never assume anything. People always come in and say, "I don't really need to put that in the will because my kids already know what I want done." And I tell them, "Trust me, they may not and probably won't." I mean, I have literally had grown adults sitting in my office in their 40s and 50s, really and truly arguing about "Mommy loved you better." After all, I'm sure some of you can attest, myself included, times when, your old adult siblings get together and inevitably conversations turn to events that happened in your childhood and an argument ensues. It happens. We're human. The other thing to keep in mind is everyone handles grief differently. You never know how someone's going to respond when they're grieving the loss of a loved one. So the best approach to try to avoid some of these family tensions when you pass on is to talk to your family ahead of time. Now, some people tell me, "I just don't feel comfortable doing that." So I advise them, well, how about we write something in the will where we explain why you're doing what you're doing, so your children will hopefully understand. Or alternatively, you can draft a letter and we'll put it in a sealed envelope, keep it with your will to be opened in the event of your death. That way, because when you pass on, you're not going to be around to tell your children, what your intentions were. But at least if you leave a writing, then when they're in the midst of that grief and anger, just believe they can at least read what your intentions are. And hopefully after reading it a couple of times, it'll sink in and maybe they'll understand it a little bit better. If you can, it's always advisable to specifically state who is going to get what regarding personal property. That way you're not going to have any personal fights. Or alternatively, I advise inserting a clause that if no agreement is reached amongst the beneficiaries within X amount of time, usually 90 days to 6 months, then the executor will sell any disputed item and then divide up the proceeds equally between your heirs. Okay, going back into the crypt again. Okay, now we're to the final nightmare, nightmare number 5. Something wicked this way comes. The tale of the man who forgot to change his will. Now, Suave Steve had been married to Wicked Wendy. It was not a happy marriage, and Suave Steve eventually happily divorced Wicked Wendy. Suave Steve, after a couple of years, met the love of his life, Kind Catherine. He loved Kind Catherine. He couldn't wait to spend the rest of his life with her. But one day, Suave Steve oh my God, I just totally back to Suave Steve and Wicked Wendy. Now, Suave Steve and Kind Catherine got married and they were so in love. Even though Wicked Wendy kept interfering in their marriage, they didn't have kids together. She just didn't like the fact that Suave Steve had remarried. Well, one day Suave Steve was so upset over Wicked Wendy's and her shenanigans, he had a heart attack and died on the spot. Poor Kind Catherine was very sad. She was sobbing because the love of her life had died, but she knew that Suave Steve, He had a will, so she was going to be taken care of. No doubt in her mind. All of a sudden, Wicked Wendy appeared at her house waving a document. And kind of Catherine's like, why are you here? What's that document? My husband just died. And Wicked Wendy started cackling and she said, ha ha ha. She's like, this is Suave Steve's will. When we were married, he never changed his will, and everything that he owned then and now is mine, including this house. Because you see, Suave Steve had the house titled in his name only. He had always intended for kind Catherine to have that house. He just never put her on the deed, and then he never executed a new will transferring the ownership to kind Catherine. Instead, his will left it to Wicked Wendy. So Wicked Wendy ordered kind Catherine out of the house, and poor kind Catherine lived a very sad life. You see, she was homeless, heartbroken, and penniless. Sometimes they say you can still hear her cries of woe on a moonlit night. Some even say she haunts poor Suave Steve's ghost. You see, life changes for all of us. You know, we may get married, divorced, our spouse may die and we become widowed. We may have a child, and then our children grow up and they no longer need guardians, or perhaps, you know, one of our loved ones, whether it's a spouse or a child, is disabled, and they, in order to protect their Medicare and Medicaid benefits and SDI benefits, we need to set up a special needs trust for them. So I always tell my clients that life changes equals time to look at your estate plan. Even if your life hasn't changed, I recommend to my clients that they review their estate planning documents, you know, every, couple of years, just to make sure the documents say what they want, and the same with their life insurance beneficiaries and 401k and retirement beneficiaries. And definitely, if something changes in your life, such as you get married or divorced, then you definitely should call your friendly estate planning attorney and have them review your estate plan with you and determine whether or not changes need to be made in light of those circumstances, because you don't want to be a Suave Steve. No, because kind Catherine was not very happy with Suave Steve at the end of things. So thank you all so much for listening to this presentation. I hope you found it helpful. If you have any questions, you can drop them in the comments section below, or you can reach out to me at kmcintosh@nclegalcounsel.com. The information is there on the screen. And I encourage you to share this presentation with anyone you think might find it useful. And also, I just want to remind you that next month we will be having our monthly webinar on Wednesday, November the 25th at 11 o'clock a.m. And it's going to be Gobble Till You Wobble, the 5 estate planning mistakes parents make. If you're a parent, you definitely need to attend this webinar. And if you know any parents, then definitely let them know about this webinar. And as always, I will be posting these webinars online when we're finished. Thanks, and have a great day.